I will start over again. Our first presenter today is Alan Fisher with Sage Divorce Planning. He is a fully licensed and seasoned financial advisor since 2000 and a certified divorce financial analyst since 2005. He's also the president of Sage Financial Management and Sage Divorce Planning in Melbourne, Florida. After his 13-year marriage ended with an acrimonious divorce, arguably forced upon him by an abusive judicial system in 2003, Alan realized that there had to be a caring and more advantageous way to equitably split assets and also allow for continued family relationships post-divorce. So working with disciples of Stu Webb, the founder and originator of Collaborative Practice, Alan became collaboratively trained in 2006. And since then has dedicated his practice to helping divorcing couples work together to equitably divide their assets and avoid the financial pitfalls of divorce. Alan has extensive training experience in collaborative practice, is a founding member and former Vice President of the Collaborative Association of Brevard, and was instrumental in helping resurrect the Collaborative Law Group of Central Florida, the largest collaborative group in the state, which now has over 100 collaboratively trained professionals. Alan was also involved in helping to create the very first course syllabus on collaborative practice that's now being taught at the University of Florida, Levin College of Law. And he's also written numerous articles and lectured extensively on collaborative practice and the financial neutral's role in that process. He's currently in the process of writing a book on his experiences that will surely be an eye-opener for those who think the justice is found in our courts when it comes to family matters. And his motto is, "I care because I've been there." And I'm going to turn it over now to Alan.
Ooh, that's a lot of things, and thank
you
for it. I do appreciate it. And yes, I have been involved in this for quite some time, and I'm thrilled and excited about being able to present all this information on collaborative practice. As you mentioned, we have a lot of things to cover today in a very short time. So I would ask the attendees as we go through this to write down your questions, save them for the end because there'll be a question and answer period at the end of the presentation, and some of the questions that you may have may actually be answered as we go a little bit further into the presentation. So that being said, what we're going to be is I hope everybody can see the slides. What we're going to talk about today are the what's, how's, when's, where's, and why's of collaborative practice. Online with me we have our other professionals as well, and when we get to those slides they will chime in and certainly talk about their area of expertise. So let's move forward on this and see where we go. What is collaborative practice? Well, in essence, it's a dispute resolution where we have settlement by agreement, and it's something that the couple actively pursues and is cooperative in order to resolve their dispute. It does replace the adversarial techniques of litigation, and the couple is actually a participatory or participating in their own divorce. We as professionals will help guide them, but it's their divorce, and they need to understand that as we go through this process. Let's discuss a little bit about the framework of collaborative practice. In collaborative practice, the lawyers, the attorneys are disqualified from litigation. We are not going to litigate under any circumstance within the collaborative model. We say that clients delay or suspend litigation if they're already involved in a litigating procedure. They can actually stop that, suspend it, delay it, and opt to go into the collaborative model. I think as you understand a little bit more, you'll see that it is really the only win-win scenario for everybody. In this case, in collaborative, each client does have independent counsel, and again, like I said before, actively participates in those negotiations. So each client will have their own lawyer just to protect them on the legal end of things. Let's go to the next slide here. The discovery is willing. Now, typically when you go through a divorce, you know that you have to have a discovery. We have to understand what the facts are, what the information is. But this is a no hide the ball. Everything is transparent. We expect honesty. We expect everything to be open, and we expect actually a safe environment so that nobody thinks that anything is being hidden from each other. If we need to bring in experts, they are jointly retained. In other words, the couple agrees that these are the people that we want to bring into the system. And also, they are disqualified from any litigation unless the parties agree otherwise. In case we have to go to litigation, in case the process falls apart, the experts may be the only people that can get into the litigation procedure if and when it's necessary. Of course, we hope that never is necessary. But experts are the only one, and we're not talking about the professionals involved, the attorney, the mental health professional, and the financial neutral. We're talking about secondary experts, if that's necessary. The goal, though, is to reach an agreement on all the elements with participation in good faith in the process. In collaborative practice, we're looking really at a team, and we recognize that there are three parts to the collaborative model: the legal, the emotional, and the financial. And some people may think that this is actually equal. My personal belief is that divorce is much more emotional than legal and financial. It's about 60% emotional, 20% legal, 20% financial. And dealing with the emotional aspects of it is by far, in my opinion, the most difficult. Now, of course, our lawyers and other financial people might disagree, but that's my opinion on that. So the fundamental question here is, if you must divorce, would you like to minimize the stress to help you achieve the best results possible for you and your children? It's kind of a setup question, and of course, in all the years that I've been doing this, I haven't had one person when I've asked this question say no. Everybody says yes. So then it kind of brings them into the whole system of what happens next. Well, in collaborative process, how does it actually work? We have participatory meetings, and what that means is we all get together. We understand what is necessary here. We focus on the future. What are people's interests? What are our goals, our short and long-term goals, our current needs? Again, we're negotiating transparently. Everything is laid out in an open and honest fashion. We are managing the process for privacy. We make sure that what happens in collaborative practice stays in collaborative practice, sort of like Vegas. And I was a Boy Scout, a Cub Master years ago, and what we always said was that we always move as fast as the slowest hiker. Same thing with collaborative practice. We set our pace based upon the ability of our clients to understand, to move along. And typically, in most divorces, there's going to be one of the parties who is much further ahead than the other. Maybe it's the one that initiated the divorce, and the other one is still, in shock from all of this. So, of course, we have to adjust our pace to that person who is in shock. We do that by working cooperatively with everybody, obtaining the information, exploring the options, of course, and problem solving as we go. We never give up. This is a process that may take some time, but it's not going to be as long, certainly, as litigation. The team itself, all of the people involved, we're going to be focusing on the financial, the coaching, the consulting, all for a common purpose. What are the best results for everybody? Not the best results for him or her, but for the couple themselves, as well as for the professionals involved. The professionals have certain needs that have to be addressed both legally, financially, and certainly in the mental health capacity. So really we're structuring the divorce for the couple, but the professionals also have certain criteria in order to make sure that the couple moves forward appropriately and can move on with their lives. Leveling the playing field is kind of interesting. Oops, sorry about that. What we do when we're working with that is making sure typically one party of the divorce may have more control, maybe have been in charge of the finances more, and the other party really doesn't understand what's happening. So certainly on the financial end, I try to explain it so that it's understandable. Again, on the legal end and on the mental health end, that would be those professionals' responsibility to level the playing field and make sure everybody is moving along at the same pace and understands what needs to be done. Supporting all participants and stakeholders, making sure, again, that everybody understands what's happening and can ask questions and move along in the way that makes them most comfortable. And again, by doing that, we are achieving efficiencies, acknowledging mutual interdependence. And I don't say dependence on one another, I say interdependence, primarily because we want everybody to get along post-divorce, and you're not going to be necessarily dependent on each other, but there are going to be things that you're going to have to rely on the other person for, certainly further communication, especially when children are involved. We're going to model teamwork, and we're going to align all of the team members, again, towards that common goal that we all want, and that is a win-win part of a divorce. While we're doing all of this, certainly we're looking at it in real time. We're making sure that it's happening now. Excuse me, let me go back to that slide for a second. And we're all going to stay focused and be dynamic and concentrate on what we need to accomplish. Okay. How does collaborative practice work? Well, we signed something called the participation agreement, and I'll get into that a little bit further into our slides. But that's really the glue that holds the whole concept and practice together. We develop our interests, concerns, and goals. We understand what those are going to be. And we certainly need to address immediate concerns when we involve in the collaborative model. Sometimes there are children issues. Sometimes there are financial issues that need to be addressed. Remember, when you're dealing with a divorce, you're dealing with a couple that is emotional at this point. It's arguably the third most stressful time in somebody's life, the first being a death, and the second maybe being incarcerated. And third is a divorce, and a divorce can similarly be, like a death. And we'll ask Eileen to chime in on that when time is right. Excuse me. So we're going to gather the necessary information, and we're going to brainstorm all possible solutions. We're going to select mutually acceptable solutions, and we're actually going to try to understand, what is right and what is doable at that point. This first slide, is kind of what happens in the adversarial practice. Everybody's trying to get what they think they deserve, and there's, the abyss is in the middle that nobody wants to fall into, and they're tugging at it. They're trying to keep away, from that horrible abyss. In collaborative practice, this is more of the solution. We're all working together to try to really understand the best scenario. Let's talk about a little this participation agreement that I mentioned earlier. Each professional typically has their own participation agreement, and what it does is it really sets the rules and expectations of what we want in the collaborative model. It's an engagement letter, basically, and I have my own that I've used with clients for many, many years. It tells a little bit about what I do as a financial consultant, that I'm going to gather the information and deal with the cash flows and the career prospects and valuations of anything that needs to be done, and do an analysis. It also talks about the responsibility of the client. It defines the limiting engagement of the lawyers in the collaborative model, again, when the lawyer has their participation agreement, and talks certainly about confidentiality, disclosure, opting out if you need to opt out of the system. Now, this is going pretty fast, and it's going to probably go to the next slide, so let me go back to this for a second. Okay. Just one more thing on the participation agreement. Both clients need to sign it. The fees will be included typically in the participation agreement of all the professionals, and both clients need to sign it because, again, it's acting together jointly to make this all happen, acting collaboratively. So when will collaborative practice work? Well, when the clients want control over the outcome and certainly are willing to participate. That's key. If you ever have been involved in the legal process in any way, shape, or form, courts and the system typically takes control of you, your life, and the outcome. We don't allow that in collaborative practice. You, the client, are involved in that and are asked to participate along the way. When a continuing relationship is desired or required. Now, certainly saying, well, why would a continuing relationship be desired if we're getting divorced. What about children? If children are involved, they're for life, and you're always going to have, activities with them, marriages, events. What about in-laws? What if you like your in-laws, you just don't like your future ex? Well, there may be other relationships that are required, and certainly if you practice good communication skills and you understand what the future, may bring, and it's fair and equitable, and it's a satisfying situation. It may not be a happy situation per se, but at least it's satisfying for the participants. When resources matter, the money, the time in each day, the energy, and lost opportunities, when time elapsed matters, how long is this process going to take ultimately? When privacy matters, again, what happens in collaboration stays in collaboration. It's not public record, as is most litigation. And certainly when you don't think you're going to get what you need in court. When most people do not, it's said that the best decision a judge can make is a decision that neither party likes. And that typically is what happens in litigation and in court. And I think Sean will probably attest to that when he talks about it. Oh, that's another one that went pretty quick, so let me go back to that slide. This is just a little slide because collaborative practice not only works in family law for divorce, but we can really use collaborative practice in other relationships, as it were, including landlord-tenant and employment disputes, and that's something for maybe a future presentation, but I wanted to address that now. It's not only possible to use it with divorce, but it certainly can be used in other areas because it's dealing with good communication in general. So where will it work? Well, again, financial services, healthcare, and a lot of these areas, intellectual property, business, and again, separate from the divorce, but I just wanted to show these slides because I wanted people to understand that collaborative practice is not just for divorce. We're focusing on that area of it now, and certainly that's our specialty. So at this point, I want to introduce Sean Kutchell. I'm going to let Sean talk about the attorney's role in the collaborative process. Sean, you there?
I am, Alan. Hope everyone can hear me okay.
I certainly can. Hope everybody else can as well.
Okay. As you heard Alan talking about earlier, talking about the process of divorce, the legal, the financial, and the emotional, I certainly would agree with Alan about the emotional aspect. And that's the collaborative process is really good at dealing with that. The attorney's roles, our role is really to represent the individual client. There's contracts that are going to be signed. Ultimately, there's agreements. We have to work sort of within the framework of Florida statutes, and we also want to make sure that any settlement is fair and that our clients are not being taken advantage of, which doesn't, of course, typically happen in the collaborative process. But at the same time, it's when we do come out with an agreement ultimately settling a divorce case, we want to make sure that it'll stand any legal tests or challenges in the future. Of course, we hope that it doesn't. It's not necessary.
Okay.
Part of also what we do is we work collaboratively with the other lawyer. We help facilitate the exchange of information, financial and financial and otherwise. Try to maintain the lines of communication and try to manage the expectations and interests both of our clients and communicate that to the other party's attorneys as well. Then, of course, we draft and prepare all the documents.
Yeah, a lot of what the lawyer tends to do also is managing the client's expectations, with the collaborative process. A part of it is still educating them. Remember, a lot of the clients are afraid, and they're looking for your expertise, Sean, regarding all of this.
Yes, and a lot of the what we find unreasonable expectations going into a process, that's a barrier to an ultimate successful resolution. So we try to manage the expectations of the participants, and not only that, and then educate them about the risks and benefits of collaborative versus, I should say, the risk of the adversarial system versus the benefits of the collaborative. Mainly with the adversarial system, you're going to have a third party making decisions for you. That third party is typically going to make those decisions based on very little information and essentially a snap judgment, maybe 2, 3, 4 hours of evidence is being presented, and you're absolutely right. In a good judgment coming from a judge is one where both parties are unhappy.
Sean, can you just please tell our audience briefly that pie tin story? I've worked with Sean in the past, and his pie tin story is just so interesting that I want you to just share that with our audience.
Sure, and and every time I tell the story, I do. I know my mother's not listening, but I apologize in advance for airing the dirty laundry of the family, so to speak. But I was visiting my mother's house over over the holidays, and my mother had baked a cake. Now my parents were divorced back when I was in high school, and it was a very contentious divorce. It ended up lasting roughly 3 years in litigation, and so fast forward 20-some years later, I was married. I had 3 children, visiting my mother, and she made a birthday cake, and brought the birthday cake out, and we sang happy birthday, and she said, well, and it was a single layer cake. It was one of those round cake pans, and she said, in all seriousness, I would have baked you a double layer cake, but your father got the other pie tin in the divorce.
Yeah, it's a way of splitting things up equitably, as it were, but not necessarily caring about how the ultimate results occurred for the child in that case.
Exactly, and it's again, it was some 20 years post-divorce, and when you find in an adversarial process, you are in fact spending not only time and money, but your emotional resources in fighting over things that really aren't important. And when I talk to people in person, I actually bring a pie pan, and I picked it up at Walmart, I think, for $3 and change. But the pie pan turns out to be incredibly expensive, both monetarily and emotionally, if you choose the adversarial process to go through your divorce.
Fascinating story, great story. Thank you for sharing that, Sean. I want to talk now a little bit, I actually want to introduce Eileen and let her talk a little bit about the mental health's role in the collaborative process. Eileen, why don't you tell a little bit about yourself also, and then talk a little bit about what the mental health professional does. Okay. Are you there, Eileen?
Thank you, Alan. I'm here. Thank you, Alan. I am a practicing child psychotherapist, and I've been practicing for 12 years here in Florida. And essentially what I do is I treat all childhood disorders. The treatment approach that I use most of the time is art and play therapy, cognitive behavior therapy, but more important for everybody who's connected today here is that I work with a lot of divorcing couples and their children, helping the children to get over this, to survive the process of their parents divorcing, and also to teach those parents how to keep in touch with your children, how to look at them, how to know what's actually going on with them, and how to properly parent those children. So that's essentially what I do in a very short synopsis. All right,
and
let's talk about...
what is your role in the collaborative process?
Oh, my role as the mental health specialist is a key role because, as we know, divorce is a very emotional process. And I don't know if we've ever dealt with any divorce that people were not emotional or angry or frustrated or confused. So my role essentially is see what's going on, be in touch with those people, kind of like have my finger on the pulse, so to speak, knowing what's happening most of the time, and trying to resolve those issues, whatever they might be. All right? So
the differences of the coach, the divorce coach, as it were, as opposed to the therapist that you are.
Okay. Well, it's a very, very different role for me, a very, very different hat for me to wear. Of course, my training is treating and therapy. But in this particular situation of being that collaborative divorce coach, I'm not doing any of that. I am partnering with these people, with this divorcing couple. I am there whenever they need me. And many instances, I do different things with different couples based upon what their needs are. I am there for them. I'm identifying and dealing with the obstacles that come to the surface, and also dealing with those obstacles and making sure that they are no longer obstacles so we can actually move forward. But it's interesting, I'm actually dealing with a family right now that there's a major obstacle with dad having numerous girlfriends, and each week there's another girl that comes in. It's really creating havoc in the process. So it's addressing it, it's eliminating it, so we can keep this process moving forward.
Okay. And as you're I'm going through some of the slides here. I'm showing some of the presentation. So if you can just address some of the things that you see on the slides as well.
Okay. Let's talk about divorce being amicable. Now, I'm sure all of you know that's sometimes a very, very difficult thing because most divorces are not amicable. So you ask yourself, okay, how is she going to be able to, make a divorce amicable? Well, my quick, fast answer to everybody is I put out fires. All right? That's what I do. And taking a look at, okay, healthy communication skills, they usually don't have healthy communication skills. So it's me looking at them and saying, okay, you're not playing fair, you're not listening, you're not respecting what the person is saying, all right, and this is what we have to establish, these communication rules, so that we get resolution to these problems. Anxieties. Well, there's a lot of anxiety in this process, a lot of fear and sadness and anger and doubt and confusion. We've got to keep it at a minimum, all right? And we have to know what is causing these anxieties in order for me to fix them and to help them to learn how to fix them themselves. Also, too, which was not added, but I think that I would like to add it, is since my role is now just being a coach and not a psychotherapist, if I'm actually seeing that there are mental health issues that surface, I cannot treat those particular issues. I would make recommendations and I would make referrals to treating therapists so that someone else could address those issues, and that does not become an obstacle in the process. Also, too, one of the roles is to identify the interests and the priorities and the concerns of the divorcing couple and helping them to achieve, what their goals are. All right, as a psychotherapist, all right, I would be going into the past. I would be looking at what those problems are that brings us to today's issues. But as a coach, we're not doing that. The only thing we're looking at is the present and the future. What's surfacing now? What can we fix now so it doesn't become a problem in the future? All right, let's take a look at co-parenting. As a child therapist, this really resonates for me because I see constantly what's going on at Dad's home and what's going on at Mom's home. For example, I have a family now. Dad lets the kids stay up till 11 o'clock at night. Mom puts them to bed at 8:30. So what's happening is havoc in the child's life of constantly adjusting and having transitional problems because they have to keep readjusting depending upon which home they're going to. So getting the parents to understand how they're going in their own directions impacts on the child and what it does to them in their lives pulls them together so that they can move in the same direction. And once we get them to move in the same direction, we will be able to formulate a very good parenting plan.
Okay, excellent.
All right, let's go to the next screen and look at coming under the heading of the coach being the case manager. Well, sometimes we're in situations where there are two collaborative coaches, and sometimes I'm in situations when there's just me, all right? If there's just me, I'm wearing a third hat. I'm organizing the process, but when there is two of us, we kind of coordinate and make the decision as to which one of us is going to wear the case manager hat. So organizing the process actually means scheduling the meetings, preparing the agendas, and summarize what's going on in the meetings. Also, too, the couple has deadlines, things that they must achieve within a certain time frame. Most of the time, they do not achieve this. So it's being on top of this, being in touch with them on a regular basis, knowing where they're at in the process, and if they're missing the deadlines, always getting with the team members, whether it's by email or by phone or presently with them, informing them of what's happening, where we're at, why things are happening the way they are happening. Okay, let's take a look at my other hat, being a child specialist. What that means to me is my loyalties fully lie with fostering what is best for the children. Children get lost in the shuffle and divorces. Unless children reveal externalizing behaviors, nobody knows, especially the parents, that children are having problems. Well, from my professional experience, I will tell you most of the time we're not seeing the externalizing behaviors, we're seeing internalizing behaviors. Children are avoiding parties, socials, get-togethers. They're off by themselves. They might be texting more or being with their friends more. They're just checking out. They don't want to be around people. They don't want to talk. They may not even want you to sit down at the dinner table with them. All right? So they're retreating. All right? My role is to find out what's going on here. So if I'm seeing one or two or three children, initially I will meet with them individually. And as time goes on, what happens in the process is I'm listening to what they're saying to me. They're sharing their experiences, their fears, their doubts, their confusions on what goes on a daily basis in their lives. They've got lots of questions. I'm there to answer those questions. I actually spend time explaining to them what exactly does divorce mean. What happens to other families and other children. It is a very comforting thing for children to understand that other children are going through the same thing, that it's just not them alone that is experiencing this. So I'm there for the comfort, and I'm there to support them, and I'm there to help them have a voice in this process.
Oftentimes they are the victims that nobody really hears in the legal system, they become more chattel than anything else. And it's important that in the collaborative process, people know that we do take the children's voice into consideration.
Absolutely, absolutely. But as also the child specialist, parents will not be left out in this. Even though my loyalty lies with those children, I am essentially the go-between between the children and the parents. Children provide so much good information to me, and what do I do with that good information? I sit down with the parents and I say to them, okay, this is what's going on with your child. This is what your child has shared with me. And by knowing this information, parents are better able to make better lifetime decisions, and taking those lifetime decisions and putting them into a very effective parenting plan. So as this go-between, I learn about their special needs, and I learn about their concerns and each of their perspectives. And I bring this information to the parents and let them know what's actually happening so they can help their own children. Parents also have an opportunity to sit down with me and share their difficulties in the co-parenting situation. One might want to co-parent, and the other one might, want to do his or her own thing. I explain it to them in terms of how it impacts on their children's lives, because it's not about them. It's not about who wins this battle and who gets their way. It's really the effect that it has on their children. So knowing about all this that the children share with me, I can tell the parents about good information, suggestions that come from their children, and also recommendations on how they can use it and incorporate it into the parenting plan once we actually sit down and formulate that. And that parenting plan becomes a guide for them in the future to know what to do, what the right things to do for their children.
Excellent. And one of the other things that I know that you've done, because you've done it with me and with other team members, is that you inform us as other professionals within the team what we can say, what we should not say, that may be points that are hot buttons with the clients and or the children if they were involved also, which is just a whole nother aspect of the team interrelationships.
Absolutely. Yes,
yeah.
Absolutely.
I want to bring Sean back. And Sean, I'm sorry, I didn't get a chance to ask you to just tell a little bit about yourself before as an attorney and your background. And then I want you to talk a little bit about mediation role as well. So if you wouldn't mind.
Sure. And sorry for not covering that earlier. I've been an attorney for about 10 years. I attended Seton Hall University in Newark, New Jersey, for law school, and licensed in New Jersey, California, and Florida. I was certified as a mediator in New Jersey within the first year after graduation. I did a clerkship in New Jersey Superior Court for a civil court judge, and I was a volunteer mediator during that year, and I'm a big believer in the mediation process.
Now, we were going to have Brooke, their attorney Goldfarb, talk about mediation, but unfortunately she was called away on, she's a professor at university, local university, and she had to teach this class, so she was not able to join us today. So I'm going to ask you, Sean, to talk a little bit about mediation and what mediation process does.
A mediator is essentially a neutral third party who may or may not be an attorney, and that person is somebody who is just trying to unite the interests of both parties in order to try to reach a settlement on all of the issues, preferably. But sometimes, if there's just one or two issues that the parties can't agree on, a mediator can do that as well. Our role as a mediator, if we are attorneys, we don't give legal advice. We can give a little bit of guidance in terms of what happens in the adversarial process. For example, how long it would take, what the judges' calendars are like, that sort of thing. But we don't act as as attorneys. It is cost effective. Mediators typically charge an hourly rate. It's not unusual to, and Brooke is a very good mediator. She's also an attorney. For example, if she often will consult with a couple who's divorcing and mediate an agreement with them, even if both parties are not even represented by attorneys, and do it in a way that it satisfies the needs and desires and the best interests of the children, and do it in a cost-effective and time-saving manner, and put together an agreement that will hold up in court if it needs to be challenged later. The people who are good candidates for mediation are people who have some level of communication. And the slide here says couples with large estates should avoid mediation. It's absolutely true. In a mediation situation, you're typically not going to have the benefit of an independent financial professional. If you have a large estate, or even if you don't have a whole lot of liquid assets, for example, but you have a substantial amount in retirement, 401k, assets like that, it's very important to have a financial professional help you through the process. And also couples with disparate incomes, if you have one party making substantially more than the other, those people should avoid the mediation process as well. In situations like that, oftentimes there's not as much transparency as there is in the collaborative process, and the collaborative process would be a much better way to go for somebody in those situations. But an average divorcing couple without children, or if the older children who are out of school, those people would be ideal candidates for the mediation process.
Yeah, there are various ways of dealing with divorce, again, outside the court system, and mediation certainly is a viable option for many, many people. But there are things to be concerned about, and people have to be aware of all of that. So thank you very much. All right, I want to talk a little bit about the financial specialist role in the collaborative process. And I know we have a lot of information here, so please just bear with us. In the role as a financial neutral, I work with both of the parties. I try to gather, certainly as much information as I can from them, and I review the information. I help in the decision-making process, and I provide that safe and comfortable setting to make sure that everybody is on the same page. A lot of what divorce is going to come down to a number, sooner or later. And trust is a big factor, and lack of trust is even a bigger factor in the divorce process. People don't trust one another. So as a financial neutral, if I'm not working for either party, but instead working for both, they each have to understand that I am there to review the information, gather and organize it, and equalize it, and equitably make suggestions on how we can divide the assets that they've accumulated over the years. I work with, of course, all the other professionals. If I have an issue, I may email the other professionals involved. I may talk to them. We may have lunch together. However the communication occurs, we always stay in touch with one another. Most of the time, it's a quick email if I have a concern about something. But I try to understand what the projections are going to be after the divorce. What is going to happen, for each of the people in this relationship? Will they be able to survive? Years ago, quite often the wife, for instance, would want to have the house and raise the kids in the same house, the marital home that the kids were born in. Well, now it's a whole other story. Now the house is not necessarily an asset, but a detriment because they can't afford, the mortgage, and they're, underwater on the home right now. So a lot of interesting facets occur, with the financial end of things. And of course, I evaluate the tax consequences and the budgeting and all of that as the financial neutral. But again, my role is not to tell them what to do, but to tell them what the results are going to be if they do certain things, and then let them make the decision. So what happens if there's a breakdown in the collaborative process? What happens when one person says, I've had enough, I can't trust that person, and I want to go to court, for it, or if there's an abuse, of the process? Well, it can, you can ultimately go that route. I remember working with a couple who were so adversarial in the collaborative process that the professionals said, this is just not going to work. You guys need to go to court, and deal with this. And they each turned to us and they said, no, we don't want to go to court. That we'll never get anything that we, want in court. We want to continue in this process, even though it's emotional, even though it's challenging, because we know we'll ultimately get the best situation. If, in fact, though, that a couple does have to go to court, the professionals can assist them, maybe make certain recommendations to other professionals. But remember, once we sign that participation agreement as professionals, we are not allowed to go into court and disclose any of the information that we received in the collaborative process. In other words, the clients have to start from scratch and get new people involved, and yes, that would be new costs involved as well. So hopefully, they don't do that. As far as the ethics go, there is going to be informed consent. The attorneys, certainly will do zealous representation. But again, in the collaborative process, when the attorneys are representing one party, they also understand the needs and wants of the other party as well. We do make sure that the clients understand everything about the process. Again, with the participation agreement, I personally have a full disclosure agreement because not only am I a certified divorce financial analyst, I'm also a financial advisor. And there have been times where the clients, after the divorce, come to me and want me to help them with their finances because I've worked with them through the divorce and I know their whole situation. As long as it's okay for both clients and they both want me to do that, while it's challenging, I sometimes will do that as well, depending upon the clients and the situation. But each discipline have our own ethics and our own rules of what we can and should not and should do during the divorce and after the divorce. This is an interesting slide, the decoder time. Remember years ago, it used to be, it was a Dick Tracy or the Green Lantern or somebody. He had this ring, and you had to tell the truth when you looked into the ring. Well, this question actually is the best decoder question that I've ever found in the divorce process. You look at the person and you say, what do you expect to happen? What would you like to have occurring in this process? And then you shut up. You listen to what they ultimately want. What that does is a couple of things. It takes the onus off of you. It takes the argument out. And now you're listening. You really try to understand what they want to achieve out of all of this. And by so doing, you understand the facts and the feelings, what's involved, what things need to be considered, what are the macro goals, the big goals. We try not to get necessarily into the nitty-gritty at the very first meeting. We'll get into the costs of the house and the kids' schooling and lunch meals and all of that. That's all the nitty-gritty. I'm thinking about things like, what kind of relationship would you like to have with your family afterwards? What are the larger, more important issues that we have to deal with? Okay? So what are the choices at that point once we understand what the feelings and the facts are? And what are the possibilities? We explore all of them. We think outside of the box. Excuse me. We consider everything. And even if it's not necessarily optimal, especially for the house, let's say the wife wants the house, but she can't afford it. Well, what about taking in a boarder? I'm sorry, I have young children. I would not think of taking somebody that I don't know in the house to help pay the mortgage. Okay, but we discussed it. It may not be practical. It may not even be correct, but we discuss it. We throw everything out there that's necessary. And if we did do any of those, what would be the consequences of those decisions? What would each option bring? The consequences for you, the consequences for your spouse. Again, we have everybody into consideration here. And then we have to, of course, understand what the short, intermediate, and long-term impacts of those decisions might be. Once we have all of that, we say, okay, are we ready to make those decisions? Is that the best decision? Are there any other alternatives that we haven't thought about? And are you comfortable with it? Are you satisfied? And what this really brings is a self-discovery for not only the clients, but the professionals involved. Quite often, when somebody is new to the collaborative model as a team member, they say, wow, I can't believe I haven't been doing this all along. We've been dealing in court issues. I myself have gone into court as an expert witness on divorce cases, and I come out just sick to my stomach with what goes on there. So this is just a new way of really discovering. It's a paradigm shift in how we think and what actually happens, from adversarial to cooperative, from dealing with the past and blame to what's going to happen in the future, from the facts to relationships, from blaming to impact, from a win-lose compromise situation to an ultimately win-win restructuring relationships and coming to certain conclusions. So really, what are the dispute resolution alternatives that we have? We have collaborative practice. We have pro se, which is doing it on your own. Mediation, we discussed. Sometimes arbitration, and of course, the war, which would be litigation. My premise is that collaborative practice, collaborative law, is ultimately the only win-win situation out there. And considering what our options are, especially in today's economy, collaborative practice would be the best solution for most people out there, 95%. There are exceptions, and we can get into that a little bit with the question and answer period. But for people who've used the collaborative process, this is what some of my clients have said over the years. It was very emotional, but also very empowering. For me to negotiate a settlement, I felt was fair to both parties. It was a positive process for me. I was pleased that it cost less than I figured, and this was by a couple of engineers that I had as clients. It allows us to have sustainable amicability. It's done. I can sleep, I can laugh, I can play, all thanks to you. So at this point, Gloria, I'd like to open up the event here to some questions that people might have and see where we can go from there.
Okay, that sounds good. So if anyone has any questions, if you want to go ahead and you can either type it in to the question pane there, or if you want to raise your hand, there may be an option, I think, somewhere here on the pane where you could click the little hand thing, little hand icon, and I can call on you. I can unmute you if you like. So I tell you what, let's see. And we do have one question. Well, someone was saying that, it seems like if you're going to be using so many professionals that the costs are going to be high. So how do the fees get charged? How does that work?
All right, well, I'll take this, and then if anybody else wants to chime in with that, they can. It's funny. It's sort of like building a house. When you build a house, you have a contractor, a general contractor, but you don't necessarily want the general contractor to be doing the electrical work or the plumbing. You bring in specialists for that. Why? Because the specialists can do it cheaper and faster. Same rule of thumb applies to this. You want people that have a specialty in their field to deal with the aspects of the problems of that particular divorce. Not all divorces, I would argue, need a full financial plan and a full financial setup. Some divorces may not even need full mental health professionals, or even full legal professionals. Again, we could do that with mediators possibly. But that's for really a team approach to decide, and depending upon the situation. But for the most part, if you have assets, if you have children, if you have a long-term marriage, you want the professionals involved, in this, because it ultimately will be cheaper than a litigated divorce. Would everybody, agree to that, Sean?
Absolutely, I agree with that. If comparing apples with apples, a litigated divorce for a couple with children and assets to be divided, it's anywhere. I would say at least half the price going through the collaborative process than doing it separately. Part of the adversarial process, the collaborative process is designed to take down the roadblocks that make the adversarial process so expensive and time-consuming. So those things are being addressed as you go along, rather than having the court make those decisions. And in many cases, in an adversarial divorce, you're actually hiring 2 sets of professionals for financials, 2 sets of professionals for mental health, possibly a third to do a child custody evaluation, CPAs, tax people. It's in many cases just much more expensive to go through an adversarial process.
And God forbid I should do any of the mental health work, that Eileen is proficient in, especially, for the children. I would always, bring in a mental health professional, for most divorces. Like I said, the emotional part is critical, to deal with.
What I would like to say one thing about that, Alan, in the situations that we've been in, sometimes it's become very, very hard to actually say to people that I see there are other issues going on, and I think you need to see somebody else regarding that. The bond becomes so tight between us, and they become so trusting because we have worked so closely together, that they've opted out not to go to somebody else because they figure that they will address the issues along the way, thinking that they might get something that will help them because we've gotten so close in the collaborative process that it always seems to surface as an issue.
Right, and just again to address the cost a little bit more specifically, each professional will ask for a retainer to start working within the process, and the couple will pay the retainer of each professional, sign the retainer paperwork, and typically it's done on an hourly basis after that. Sometimes the retainers are negotiable depending upon the couple and the assets and the ability to have the money. But you want to bring in these professionals, you retain them, you sign the participation agreement, and then you're done. I mean, you're involved with the process at that point, and you move forward knowing that that's the professional that's going to be working with you throughout the whole process. Anything else, Gloria?
Well, I tell you what, we're bumping up at 1 o'clock, but I've got one more question here. This one actually is for Sean. I was wondering about how Jane was wanting to know, how do you fight for your client's legal rights in the collaborative process?
Well, it's not so much fighting for their legal rights. It's making sure that the legal rights of your client are being respected, and oftentimes the legal rights of a client are overlapping with their emotional and their financial needs. And what we do is make sure that, of course, anything that they're entitled to legally, a client would be entitled to legally, we try to incorporate in a collaborative agreement, but doing so in a way that that's benefiting everybody. It's benefiting both parties, and in a way that's not being destructive to the family and to the children. I think the best way to answer it is a client's legal rights, if we want to call them that, are not only their rights, but their desires are overlapping with their financial desires, their financial goals, and their emotional goals, and the needs of the children. And that we protect them in that way. And then, of course, we put language in the final agreement to make sure that it will stand the test of time if there's a challenge to it later on, which we hope there isn't. But also we're able to build in some creativity with agreements in a collaborative structure that we're not able to by having a judge make those decisions for you.
Yeah, that's probably one of the more important things. In collaborative process, we are able to be somewhat creative because we're looking at all of the options. There are certain things within the law and in the courts that we'll just do as a matter of rote because they must do it. In collaborative process, we have some flexibility, a lot of flexibility as a matter of fact. So that was great. Thank you. Thank you so much, Eileen. Thank you so much, Sean and Gloria, for a great discussion. I've left our information up on the screen here. If anybody wants to get in touch with anybody from our group, our team, please feel free to do so. And I'm hopeful that we can do more of these type of webinars in the future, maybe be a little bit more specific because of a specific area, because there is so much to cover with collaborative practice. I think we really just touched the surface and made this more of an introduction, but there's so much more that can be done, and I'm so proud to be a part and a big part of this process, and certainly with my team, with you people. Thank you.
All right.
You're welcome. Thanks, Alan. Thanks, Eileen.
You're welcome. Thank you.
And thank you, everybody, for attending. Thanks, Gloria.
Thank you. All right.
Okay. Bye-bye.
Bye.